To start out, is it, I'm saying it is, past time for Democrats to defy the Supreme Court? This is pretty straightforward. We've got a crisis in our democracy right now. I don't know if you caught Thomas Edsel's piece in yesterday's New York Times. If you didn't, it's really worth reading. It's called How to Tell When Your Country is Past the Point of No Return. And he's citing all these different scholars saying that basically Trumpism is on the verge of ending democracy in America. And then, of course, you got Barton Gellman's shocking piece in The Atlantic titled, Trump's Next Coup Has Already Begun. My critique of these two pieces, and I highly recommend both of them. I think every American should be reading both of these pieces, and there are hot links to them both in my article today over at HartmannReport.com. My critique of them is that neither one of them are missing the elephant in the room, GOP pun intended, which is money in politics. The Supreme Court legalized bribing politicians. They did this in a small way in the 70s. They did it in a huge way in 2010 in Citizens United. This is a doctrine that not only did not exist before the Reagan administration or before the 1970s, didn't exist at all in American law, but was openly contradicted. We had laws going back to the Tillman Act in 1907 that made it a felony. You go to prison if you gave money, if a company gave money to a candidate for political office, for federal political office. So now we've got this situation where because the Supreme Court decided in Citizens United that bribing politicians is just fine. We're not going to call it bribery anymore. We're going to call it freedom of speech. And money is speech. And corporations can get in on the act, too, because they're persons, that we've got all these crises. I mean, most Americans want their drug prices to be reasonable like they are in Canada or Europe or even Mexico. Well, not so here. Why? Because the Supreme Court lets Big Pharma bribe politicians. It's very simple. And the same is true in every single one of these cases. These situations are persisting because our politicians are taking bribes to keep them that way. $2 trillion in student loan debts. We want to strengthen Social Security, and instead the Republicans are trying to tear it apart. Bankster bailouts, health insurance ripoffs, billions in subsidies to the fossil fuel industry, billionaires paying only 1% to 3% in income taxes, and corporations paying nothing while the rest of us get soaked. 60,000 factories moving offshore, and along with them, tens of millions of good-paying jobs. Employers like Amazon and Kellogg's engaging in blatant union busting. Internet companies tracking your every move and every keystroke and then selling that information without your permission. Climate change. All of these things are crises that are not being dealt with right now by our government because politicians are being bribed. Every single one of these problems you can track back to Citizens United. I mean, Americans watch with their jaws on the floor as Senator Sinema takes $1 million or big bucks anyway, from pharma, and then votes refuses to vote to control our drug prices. As I said, there was a time in this country when this was called bribery or political corruption. And after the 1970s, when Spiro Agnew had to resign from the vice presidency for taking bribes, and Richard Nixon had to resign from the presidency in part because he was taking bribes from Jimmy Hoffa and from the milk lobby, Congress put into laws to stop this during the Jerry Ford administration in the 70s. But that was then and this is now, because 5 conservatives on the U.S. Supreme Court gutted those laws in their 2010 Citizens United decision over the loud objection of their 4 colleagues. So what do we need to do? Congress, Democrats in Congress need to take this on head on. This declaration that corporations are people and money is free speech. And the way to do that is with something called court stripping. Now, follow me along here. Republicans know exactly what I'm talking about. in 2005 in the Marriage Protection Act, which passed the House of Representatives in July 22, 2004. That law, designed to override Supreme Court protections of LGBTQ people, contained the following paragraph, quote, this is from a law passed by Republicans out of the House of Representatives, quote, no court created by an act of Congress shall have any, and of course the Supreme Court was created by an act of Congress, no court created by an act of Congress shall have any jurisdiction, and the Supreme Court shall have no appellate jurisdiction to hear or decide any question pertaining to the interpretation of or the validity under the Constitution of Section 1738C or this section. In other words, this law is constitutional because we, the Congress, say it is. And you, Supreme Court, you can't do anything about it. How did they do this? How did the Republicans do this? They did it because there's literally nothing in the Constitution that says the Supreme Court gets to decide what's constitutional and what's not, or gets to strike down laws because they say they're unconstitutional. Now, the Supreme Court took that power onto themselves in 1803, and as I've shared with you many times in the past, I won't reread it, you know, Thomas Jefferson went nuts about this. He was president at the time, and he said this is going to turn the judiciary into the most despotic form of government. They can take the Constitution and twist it and shape it in any form they please as if it were a mere thing of wax. But in the first 70 years of America being America, there were only 2 times the Supreme Court tried to rule and say, we're striking down a law or validating a law because we think that it is unconstitutional or constitutional. And only twice in the first 70 years of America did the Supreme Court do this. And both times, the then President of the United States ignored them, and the then Congress of the United States ignored them. And citing this history, in the 1950s, the Republicans started introducing literally hundreds of court stripping provisions saying, you know, that we, the Congress, get to ignore the Supreme Court into various pieces of legislation. One actually passed, the Marriage Protection Act. And, you know, Tom DeLay, by the way, was the master of this, the Republican House of Representatives back then. And this is all based on Article 3, Section 2 of the Constitution that says the Supreme Court shall have appellate jurisdiction both at the law and fact with such exceptions and under such regulations as the Congress can make. So we got, for example, in 2005, the Detainee Treatment Act of 2005. This was the Bush administration's legislation. It passed, it is law, and it says, and I quote, no court, justice, or judge shall have jurisdiction to hear or consider an application for writ of habeas corpus filed by or on behalf of an alien detained by the Department of Defense at Guantanamo Bay. In other words, they stripped that power from the court. There's even a court stripping provision in the Patriot Act of 2001, which is why back in 1980, Ronald Reagan hired a young lawyer by the name of John Roberts and said, figure out how we can overturn Roe v. Wade with legislation. And he came up with a whole series of solutions, and they all involved court stripping. Now, the odds are it'll never work. But here's the deal. In 1937, when the court was threatening to strike down Social Security, Franklin Roosevelt took them on. He said, okay, I'm going to regulate the court. And what did the court do? They changed their mind all of a sudden. So in essence, what I'm saying is, if the Democrats can find the courage to do what the Republicans have done over 100 times since Reagan became president, and put into law at least twice, if the Democrats can find the courage to do that same thing, yes, it may not work. It may not become law. The Supreme Court might ignore it. But it will start a public conversation that the Supreme Court will have to pay attention to.